warahmatullahi wabarakatuh. My name is Ali Firdausa. I'm from Law Division in Universitas Internasional Batam. Today, I want to talk about international law. First, I want to talk the definition. The international law means in modern approach is the body of law that regulates the activity of entity possessing international personality. In traditional approach is the conduct or relationship of state. Next, the division of international law. Public international law is managing relationship between state to another state. And private international law means the body of law that regulates the relation between person and entities in different states. Next, the source of international law in Article 38 of ICJ Statute. First, International Convention. The second, International Custom. And third, the General Principle of Law. Next, the subject of international law. The subject of international law means entities or elements have a capability to conduct legal acts in the field of international law. First, state. State have permanent population, government, sovereignty, recognition by the other state. Second, international organization. Organization whose member consist of state have a significant membership. For example, like United Nations and ASEAN. Third, Holy Throne. Holy Throne has sovereignty as the subject of international law. Cannot be attacked by any state in the time of war. For example, like Vatican in Roma. Belligerent. Belligerent is the group of people make an action to separate themselves from sovereignty of a state. And the last, individual. Individual is a person or citizen is a subject of international law. For example, the President of Indonesia, Mr. Joko Widodo. Now, I want to talk about human rights. The meaning of human right is those rights possessed by an individual that cannot be withdrawn or withdrawn by a state. International Bill of Human Rights, the 1948 Universal Declaration of Human Rights. Next, human rights treaties in Europe. The European Human Rights Convention contains civil and political rights that are virtually identical to those set forth in the United Nations Covenant on Civil and Political Rights. Latin America Human Rights Norms, the 1948 Charter of the Organization of American States. African Human Rights Program, the 1986 African Charter on Human and People Rights. The 1986 African Charter contained many of the human rights principles mentioned in the United Nations Charter and the United Nations Universal Declaration of Human Rights. Now, I want to talk about citizenship. The meaning of citizenship is individual nationality is a bond between an individual and a state that establish reciprocal rights and duties between them. Next, nationality. Nationality is a legal, political, and social link between the individual and the state. Next, parentage. Parentage in the child citizenship was that of the parents. The sanguinis or blood rule for established citizenship applied in Europe, Latin America, and many English-speaking countries. Birth, a nationally by birth rule. jus soli, or sole rule for determining citizenship. Next, naturalization. Individuals may actively change their nationality throughout the process of naturalization. Next, dual nationality. A dual national possesses the citizenship of more than one nation. Stateless. Individuals are stateless when they lack the nationality of any state. Loss of one original citizenship, typically conferred by birth or parentage, without obtaining a new citizenship, render the individual stateless. The individuals cannot claim the bond of citizenship with any state to protect them. Now, I want to talk about refugee. Refugee, under international law from Article A 1 verse 2 of the 1951 Geneva Convention on the Status of Refugee. A refugee is any person who owing to a well-founded fear of being persecuted for reason of race, religion, etc. Refugee legal status under international law from Article 33.1 of the 1951 Convention. A state may not return an individual to his or her homeland if his life or freedom will be threatened on account of his race, religion, nationality, membership of a particular social group, or political opinion. Now I want to talk about jurisdiction. Jurisdiction refers to the power of state to enact law the proscribed certain criminal conduct. A parent offender try them for violation of its internal law. 5. Jurisdictional principle. First, territorial principle. National principle. Passive personality principle. Protective principle. Universality principle. Now, I want to talk about recognition. The meaning of recognition is generally refers to one state willingness to establish or maintain official relation with another state or its government. Types of recognition. First, recognition of state and recognition of government. The difference between recognition of state and government: one, the recognition is given to a state, the recognition cannot be withdrawn. Recognition of a government may be lawfully withheld or withdrawn. Types of recognition of state. First, express recognition, implicit recognition, collective recognition, and premature recognition. So, that is from me. Thank you. Assalamualaikum warahmatullahi wabarakatuh.